All right, court is now on record for the afternoon criminal docket. Mr. Bingham, you ready?
Yes, sir.
All right, you're gonna have to help me with his last name.
Yes, it's King David Abiyabuchi.
Abiyabuchi. Come on down. This is cause number CR 26-53. Mr. Abiyabuchi is set for pretrial. Any announcements, Mr. Bingham?
Judge, we reached an agreement to do the pretrial intervention program. We have the paperwork that's been executed, which I can present to the court.
Yes, sir.
The 500 is not been paid, but I'm going to issue a check on a trust account and get that paid. We're supposed to do it today, but we're not going to check it. But I'll get that right to the DA's office. I sent that to Ms. Curry today, so they stay as a copy of it. They're good.
All right, Mr. Abiyabuchi, if you will raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Give me just one moment. I'm going to go over your paperwork. All my stuff's on. All my stuff's on. All right, sir. All right, Mr. Abiyabuchi. You are represented by your attorney, Mr. Matt Bingham. Are you pleased with Mr. Bingham and the work that he's done as your attorney? Do you have any questions about anything that you've agreed to and signed in your pre-trial intervention contract today? All right. And are you a United States citizen who reads, writes, and speaks English? You're not a United States citizen, but you read, write, and speak English? Okay. And you understand that entering into a pretrial intervention contract today with regard to this felony charge of possession of a controlled substance could have adverse effects on your either status in this country or your reentry into this country should you be deported. You understand that? Okay. And understanding those things, you still wish to go forward? Mr. Bingham, do you believe that your client is competent to enter into this plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after fully understanding his legal rights? And as to the issue of immigration, did you or another attorney counsel Mr. Abiyabuchi on that issue?
He also has retained immigration lawyer in Dallas. I'm blank on the name, but he's got counsel to immigration.
Okay. And Mr. Abiyabuchi, in order to enter into this contract, it looks like a part of your agreement is that you would be waiving your right to a jury trial in this matter should the contract be violated. Do you understand that by waiving your right to a jury trial, you're giving up your right to cross-examine and confront the state's witnesses and their evidence before a jury of your peers? And you understand that once you waive that right to a jury trial, that right may not be restored back to you. Meaning you can't enter into the contract and then decide, now I want a jury trial. You will have waived that. Do you understand that? And has anyone threatened you, forced you, or pressured you to waive your right to a jury trial? Okay. And you also understand you'd be waiving your right to request a speedy trial. It appears that the agreement is that you will be on this pretrial intervention contract for a period of 1 year. Is that your understanding?
So he's been incarcerated since October. So the way, what we agreed to is, we didn't file a motion for bond because he had an immigration hold. So it kind of begins back. He's getting credit for that, so it'd be 1 year. Whether he gets out or he remains in custody, because I don't know if anybody can lift their hold with this disposition, or he may remain in jail, so he will get credit towards that 1 year for the time he's set in jail. We
Yeah.
didn't.
Well, let me caution you, that's not what the contract says. Contract says for a period of 1 year from the date the contract is signed and filed with the court, and that he is not requesting or seeking early termination of the contract. That's paragraph 3 on page 1.
I was looking at the bottom. It probably, that last sentence, the contract shall receive 1 day credit towards successful completion of this contract period has been held in jail. But it does say beginning today, but that was.
Yeah, I think that last clause goes to once he's completed the contract.
Yeah, and I probably should have removed that, asked that be removed, because I think this Curry would agree that the agreement was to begin when he was incarcerated.
Well, let me just ask an obvious question. What would be the purpose of a pretrial intervention contract if he stays in jail? Doesn't do anything to show that he's complying with it. I mean, what's the purpose of putting somebody on a pretrial supervision if they're never going to be supervised other than lockdown custody?
Well, we're hoping that he would, but it would not be for the 1 year period.
So this is like a 2-month
It would be.
contract.
If he got out. And, so I understand the court's question.
It just seems very inefficient. I think if I'm 2 months from it, I don't know why. It just doesn't make sense to me.
Can we approach?
No, I'd rather have it on the record. I'm sorry. I've been put in situations before where it's off the record and it's not gone well with this DA's office, and so I'm not going to do that.
Your response, what I was concerned with is the immigration issue. So what I was trying to do is get him the credit for the time he's been in there, because if he went on pretrial conversion, what happens to the 9 months he's been sitting in jail, essentially, he'd almost have the whole sentence, or he'd have a large portion of time accumulated. So how do you know, if he's going to remain in there anyway on the immigration hold, we're trying to give him credit for that. But at the same time, he's no prior criminal history. His mom and sisters are here. They're US citizens. He was a student in college. It was a THC vape pen. So I'm trying to do something that accommodates or takes into account this long amount of time he's got, but also does not result in automatic deportation for him, because he has been here for a while. His family all lives here. They're US citizens. And the truth is, on immigration, anything that you could plead to a Class C misdemeanor, paraphernalia, you're going to deport. So according to his immigration lawyer, so I'm trying to fashion a resolution where he gets credit for that. But he's an individual, no products, was played football in college, his family's all here. If he got deported, he's going back to a country where his family isn't. And that was the spirit behind what we were trying to accomplish since he's young, no criminal history. We didn't file, the lab took a little bit longer to get stuff tested. We didn't file a motion to reduce bond or took a 17-151 motion, because then what happens is he makes bond on a criminal case, but he's still sitting in jail in immigration law. So he built up all that credit with both, and it kind of became a unique situation. And that was kind of the spirit behind it. Taking into account, he's never been in trouble before, but the immigration issues are the driving force. I'm trying to do something that allows him to remain here. And but let that credit does not just go to us.
Yeah, I understand the concern. Obviously, I've got all kinds of ideas that I could fashion for you, but that's not my job. It's their job and your job. So what I'm telling you is my probation department cannot supervise a pretrial intervention contract if he's in custody and if he's in jail. And I wouldn't want to set a precedent of authorizing a 2-month pretrial intervention contract. Because if I did that, then I'm gonna have attorneys wanting to come in here and have a 2-month felony probation period. That's what's gonna happen, you know? And so I've got to guard against the policy of a slippery slope and being open to that. So I got to remain in my policies that if it's going to be a pretrial intervention contract, it's going to be from 1 year from it being signed and filed. If y'all want to go back to the drawing board and figure something out that takes into account what you need and what the DA's office needs, I'm fine. You know, if y'all want to do that today, or if y'all want to reset, or if you want to go forward with this today, I'm fine with it. But I just
With the court, well, let me step out for a minute, go back to the drawing board, and because I certainly understand the court's concerns.
yeah. I wish, and it's nothing against you, Mr. Abiyabuchi. It's not at all. Unfortunately, as I administer your case, it's necessarily going to be applied to other cases. So it's just an unfortunate circumstance. But yes, Mr. Bingham, go ahead and have a seat, Mr. Abiyabuchi. And then Mr. Bingham, if you and the state want to renegotiate, present something different, I'm fine with dealing with that. And so, but I would like you to approach on an unrelated matter. Mr. Bingham, you want this back or do you mean hold on to it? Thank you. Mr. Schmidt, is Richard outside or something? He's going over a plea. Do we have Laterio Bates? All right, court calls cause number CR 25-180 State versus Laterio Bates. We're set for a status. Mr. Hernandez, do you have any update on the appeal from Smith County? That was my note from our last hearing. I think he's in TDC right now on one of their charges.
No, sir.
No updates? All right, do you want the court to bench warrant him or not?
And it's got a couple of words for that.
All right, court will set Mr. Bates for final status on state's prosecution. We'll set that. I'll give you till, we'll set it in October, give you a little more time. October 13th. All right, looks like Mr. Schmidt is the only attorney with any cases. Mr. White, you don't have any cases today, do you? No, I don't see you on there. Okay, I just saw you back there. I want to make sure I wasn't overlooking anything. All right, court's going to stand in recess for 20 minutes. Oh, do you need time? Okay. What were you going to say? All right, Mr. Schmidt, who are you ready on? Troy Brown, CR 26, 42, 43, 44, 45. All right, Mr. Brown is set for pretrial in all cases. All right, court finding that there are no pretrial issues, court sets Mr. Brown for docket call September 15th in each case.
Brown. Here, County. That. Remain and then. In Friday, I can go forward on Friday, yeah, I'll keep them here. I'll have to meet with them.
Yeah, unfortunately, I don't want to step on the toes of the sheriff. I know he's trying to manage the overcrowding at the jail, so I'm not sure if I don't want to issue an order that could have an unintended effect of complicating things. So if maybe you can let the sheriff's office know that, and perhaps they can make a exchange or something, put someone in his spot. Christopher Crutcher. This is cause number CR 2648, CR 2649. Mr. Crutcher is set for pretrial. Go ahead.
It's pending in the county court of law that Mr. Wheeler, as his attorney down there, Mr. Wheeler has filed a motion suggesting incompetency. You know that Mr. Dr. Proctor has been assigned a county court of law visit with Mr. Proctor that hasn't happened yet. So we asked that the pre-trial be set.
All right, court will set. It's going to be a short reset. I know it may not work with the dates downstairs, but we're going to set for 9:15.
Joan, happy fact, I have not found the same motion here because we would be duplicative, but I would ask to see that the results of that evaluation prior to moving to the Mr. Crutcher's case.
Yes, sir. And I'll inquire with Judge Winters to see if we can get a copy of that for our purposes. September 15th.
Yeah.
Joshua Allen Gladwell, CR 2575, CR 2651. Mr. Gladwell is here on pretrial for aggravated assault public servant and on motion to revoke ag assault deadly weapon. Go ahead. All right, court sets Mr. Gladwell for docket call and motion to revoke September 15th at 1:30. Jay Harrison. CR 24-137, CR 2628. Mr. Harrison is here today on the state's motion to revoke for possession controlled substance and also docket call on his newly indicted possession case. All right, court sets Mr. Harrison then for September 15th on motion to revoke and final docket call. Joshua Logan, CR 26-55. All right, Mr. Logan set for pretrial. All right, court sets Mr. Logan then for plea before the court, August 13th at 1:30. Ronnie McGee. All right, Mr. McGee is set for arraignment today. I see that he's here on a bench warrant from TDC. All right, the court enters Mr. McGee's plea of not guilty into the record. Court sets this matter for pretrial on September 15th, finds that he's waived the formal requirements of arraignment. Thomas Morris, start making your way this way. All right, this is cause number CR 24-280, State versus Thomas Wayne Morris. Mr. Morris is here for docket call. All right, court sets final docket call September 15th at 1:30. Stephen Nelson. Stephen James Nelson. This cause numbers CR 2630, CR 2638, and Mr. Nelson is here on pre-trial in each case. Thursday. All right, court sets Mr. Nelson for plea August 13th at 1:30 in each case. Evan Page. This is cause number CR 19-63, State versus Evan Andrew Page, and Mr. Page is here on docket call.
I'm looking to hear better from Curry. We had prior to, this page, I think he was taking the custody cat prayer, so it's the way we get at that. We had an offer and an agreement on the table that I haven't been able to talk about. So it's currently not what's reflected in the note, so I'm trying to get back to Ms. Curry to see if we can get him resolved. We got a short recess rather than alone.
August 25th, 2 weeks.
Sure.
All right, court sets Mr. Page for final docket call August 25th at 1:30. Julian Romero, CR 26-5. All right, Mr. Romero is here on the pretrial setting. And I think there's also a request for bond reduction. Let's take up pretrial first. All right, court will set Mr. Romero for docket call September 15th. And then as to the bond reduction. Mr. Romero, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, thank you. You can lower your hand.
Man.
Yes, sir. All right, Mr. Romero, I'm going to let you testify from there. Just speak up loudly and clearly so I can hear you, so my court reporter can type down what you're saying. Go ahead, Mr. Smith.
Let's take you. And. Yeah. For the station, right? Yes, sir. You've on $750,000. Yes, sir. And we've been in custody just now since May 2026, right? Yes, sir. Now, originally, you recall the date that you were arrested and discharged? Yes, sir. It was over a year ago, right? Yes. And you were in Manzanar County Jail for roughly 9 days. And you received the personal private 6 months in this court, is that correct? Yes, sir. And at that time, you had not been indicted on charges. Yes, sir. You were indicted roughly a year after your date of arrest, is that correct? And between the time you bonded out on PR bond in 2025 and the time when you were set to be in this court for your arraignment, had you moved from your residence? Yes, sir. And at one point or another, you're aware now that this court sent notice to your arraignment. Is that right? Yes, sir. And you were not physically present to see that notice? That's right. And in fact, you are the group residence. Yes, sir. But you did miss your first court date because you had moved residences in that period of years, so under arrest, correct? Yes, sir. But you did not willfully ignore the court's notice. No, sir. And had you physically received notice, you would have been here in this court. Yes, sir. Now, your bond said at $250,000, are you capable of making that bond? No, sir. You do have individuals in your family that may be able to help you make bond, is that correct? Yes, sir. If you have any idea if your bond would be reduced, what amount it could be? About that. So if the judge were to reduce your bond to say $40,000, you believe that you have family. And if you were to get a post bond, do you have the ability to get back and forth to court? Yes, sir. And you have a place to live? Yes, sir. You're only one month to receive it. Where is it? Purchasing Texas. You have transportation back and forth to court? Yes, sir. Also, you understand that every individual in this court is ordered to abide by pretrial release conditions. You know what those are? Yes, sir. You have to report once a month. Yes, sir. Cannot use state controlled substances. You have to pay fees to the court point, which I know. Can you abide by those conditions? Yes, sir. And can you assure the court that you are able to make law that we would make it to all of your court dates? Yes, sir. Once again, you did not intention. Finish your question. That's right. Okay.
State questions?
Thank you, Your Honor. Mr. Romero, it appears that you have at least 7 criminal convictions. Is that correct?
And Judge, I'm the vice counsel. Mr. Romero is going to shoot some question.
Your Honor, if it's of a limited purpose or does that mean or he asked that?
If
Before he arrested bond, he said he was asking questions for the limited purpose of bond. And those are my questions for the limited purpose of addressing the bond and production request.
are there potential instances of enhancement at all? Where in the state could use testimony today to prove up a prior? I'm gonna sustain his objection, but I'll still let you present the evidence whether he answers it or not. Because it's the court, and if you're unable to do it, the court's gonna review his criminal history as part of the PSRS, as I'm required to do for 17-151.
I'll just rest on the record.
Okay. Anything further, Mr. Schmidt?
No.
All right, then, any argument, Mr. Schmidt?
Just briefly, Judge, I think ultimately, we said bond, to ensure that the defendant makes his court. I don't think that at this point, generally speaking, a bond said $250,000 as a reaction to this other to appear as legitimately the court's policy. Ultimately, the time from arrest, to the time he was indicted was significant delay. And ultimately, had the case been died in the time of fashion, I don't think that it's around. We've been in a position not to get his written notice for another year. So. The argument is that the failure to appear was not will or willful disregard of the court's order for him to appear. We'd ask that, the bond be reduced to an amount reasonable enough for him to post while this case is pending. We're asking for the court to reduce it to $40,000 cash for sure.
All right, any argument, Mr. Hernandez?
Thank you.
All right, court will take the evidence and argument under advisement, and I'll issue a ruling at the end of the docket today. Jatavian Ross, CR 24-63. Mr. Ross is here today on the state's motion to revoke for evading arrest or detention of the vehicle.
You said most. What's that cost?
All right, the court sets Mr. Ross August 27th on the contested docket.
What was that again?
August 27th. So the next contested docket. Is Yaquez Thompson, is that a plea?
Yeah.
Okay. Charles Wilson III. This is cause number CR 2619, CR 2668, CR 2617, CR 2618, State versus Charles Wilson III. And I believe we're on final docket call.
Okay.
All right, court sets Mr. Wilson for plea August 13th at 1:30. Martavius Wilson, start making your way this way. Oh, he's not in custody? Okay. Yeah, right there's fine. All right, this is cause number CR 22-343, State versus Martavius DeAntoine Wilson. And Mr. Wilson, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Wilson, are you you are a United States citizen, correct? All right, it appears that you were before this court previously on January 24th of 2023, and on that date, you pled guilty to possession of a controlled substance in penalty group 1, less than 200 grams, but more than 4 grams, a second-degree felony. The court followed a plea agreement that you reached that day. The court deferred a finding of guilt, placed you on community supervision for a period of 6 years, and ordered you to pay a $1,500 fine. It was during your period of community supervision that the state filed its motion to revoke and alleged what appears to be, I believe 8, well,
That's the one I'm.
8, I think it's 8. I think it's 8 counts. I think there's just like maybe a typo, but 8 counts of allegations. Have you had an opportunity to review those with your attorney, Mr. Schmidt? Are you pleased with Mr. Schmidt and the work that he's done as your attorney? Do you have any questions about anything that you've read and signed today that's part of your plea agreement? Mr. Schmidt, do you believe your client to be competent, and if so, that he's entering into the agreement intentionally, knowingly, and voluntarily? And you've explained to him his legal rights? All right, Mr. Wilson, I see that, and let me ask, does he waive the formal reading of the state's motion?
We do.
Does he intend to plead true to all counts? All right, Mr. Wilson, it appears that your plea agreement that you've reached with the state today is upon you pleading true. The state would be recommending that the court adjudicate your guilt. That means to convict you of that underlying offense of possession of a controlled substance in penalty group 1, greater than 4 grams, less than 200 grams. And after the conviction, that your community supervision be revoked and that you be sentenced to 4 years confinement in prison, and that you be ordered to pay the balance remaining on your fines, restitution, and reimbursement fees. And you would receive credit for any time that you've spent in jail on this cost. How much credit time would that be, Mr. Schmidt? 14 days? All right, so Mr. Wilson, is that your understanding of the plea agreement and what you're asking the court to approve? All right, then at this time, I would ask you, how do you plead to counts 1 through 8? Are those counts true or not true? And are you pleading true to each one of those counts because what's alleged in those counts is in fact true? Has anyone threatened you, forced you, or pressured you to plead true to anything in court today? All right, the court will accept the defendant's plea of true to each count as alleged. Court also admits the defendant's waiver of rights and plea of true in evidence. Is there anything further from the state? From the defense? All right, Mr. Wilson, based on your plea of true and the evidence before the court finds that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement today. The court adjudicates your guilt, convicts you of possession of a controlled substance in penalty group 1 or 1B, greater than 4 grams, less than 200 grams. Court revokes your community supervision and assesses your punishment at 4 years confinement in the Texas Department of Criminal Justice and orders you to pay the balance of your financial obligations. You're awarded 14 days credit towards your sentence for the time that you have spent in jail, and you're remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with Sergeant Martinez, and he's going to take your fingerprints and take you into custody at this time. Sign that one, you should be receiving. All right, so we're working on Yaquez Thompson. Mr. Bingham is talking on Mr. Abiabuche. All right, so Mr. Thompson and Mr. Abiabuche. Is Mr. Thompson in custody? Yes. Okay. I don't know how long that's gonna be, but if he wants to take those back. Okay. Okay. All right, court's gonna stand in recess until Mr. Bingham or Mr. Schmidt is ready. Who's ready? Both of y'all ready?
Yes, sir.
Did he just go to the restroom? All right, we'll wait for him. Mr. Smith, let's go ahead and bring your client up.
Oh, he was back.
He might have been stepping into the restroom. Mr. Thompson, come on up. This is cause number CR 26-110, State of Texas versus Yaquez Trey Sean Thompson. Mr. Thompson, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Give me just one moment. I'll pull up your paperwork. Information. All right, Mr. Thompson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done for you? Do you have any questions about the paperwork that you've read over and signed today that is your plea agreement? And Mr. Schmidt, do you believe your client is competent to enter into a plea? And if so, that he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights, including waiving his right to an indictment and also the advantages and disadvantages of a deferred adjudication plea?
That's right. Right. Did explain it, his rights pertaining to presentation to the grand jury, and we proceeded to plead to an information at his request.
All right, thank you. So, Mr. Thompson, let's go over that waiver of indictment first. Do you understand that? Go ahead, Mr. Hernandez, that's okay. Mr. Thompson, do you understand that in order for you to be prosecuted for a felony in the state of Texas, the law requires that a grand jury return a true bill of indictment indicating that they believe that there is enough evidence to believe that you've committed a crime, and that absent a grand jury doing that, no one can be brought to trial for a felony. Do you understand that? Do you understand that in this case, your case has not gone to the grand jury, and the grand jury has not reviewed the evidence, and they've not made a determination on whether or not they believe that there's enough evidence to continue a prosecution on you? Do you understand that? But what you're telling me today is that through your attorney, working with the DA's office, that you've asked the DA's office to extend you an offer and allow you to resolve this case without the case going to the grand jury. And you understand by waiving your right to the grand jury that you would not get that right given back to you later. Meaning that if you go on this plea agreement, if the court approves it and places you on deferred community supervision a year down the road, and let's say things don't go well, you can't come back and say, hey, judge, my case was never presented to the grand jury, and therefore I want it presented to the grand jury. You understand that you're waiving that right today? All right. And has anyone threatened, forced, or pressured you to waive your right to an indictment? All right. Court will find that Mr. Thompson has intentionally, knowingly, and voluntarily waived his right to an indictment in this case, that he's done so with the assistance and advice of counsel, and the court approves that waiver. All right, so today it looks like by information you're being charged with a third-degree felony offense of possession of a controlled substance in penalty group 2, greater than 1 gram, less than 4 grams. And the state is recommending that in your plea agreement that upon you pleading guilty, that the court is to consider the evidence but not convict you today, rather to place you on deferred community supervision for a period of 3 years, along with a $1,500 fine, restitution in the amount of $180, court costs in the amount of $290, and reimbursement fees in the amount of $515. Do you understand that to be your plea agreement? Do you also understand that the range of punishment for this offense is not less than 2 years or more than 10 years in prison and a possible fine not to exceed $10,000? That's the full range of punishment. Should your guilt be adjudicated and you be sentenced and convicted on this offense, that's the range of punishment that you're looking at. Do you understand that? All right. Understanding of all of those things, Mr. Thompson, how do you plead to possession of a controlled substance in penalty group 2 greater than 1 gram, less than 4 grams? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? You're not? Are you pleading guilty because you are guilty? All right. And you're telling me that you're pleading guilty because you committed this crime. And has anyone threatened you, forced you, or pressured you to plead guilty? All right, court will accept the defendant's plea of guilt. Court admits the stipulated evidence and takes judicial notice of the defendant's judicial confession. Anything further from state, from the defense?
No.
All right, court will review the evidence at this time. Am I assuming correctly that there's no lab report in this case? Okay. All right, and you understand, Mr. Thompson, that the substance that was seized from you, which appears to be possibly tetrahydrocannabinol, has not been tested by the laboratory. You understand that? And by entering into this plea agreement today and waiving this report, you understand that that's not going to be tested. And so if it tested for something other than what's being alleged, that you will have waived that right. Okay. All right, then based on the evidence before the court finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement. The court hereby defers a finding of guilt, places the defendant on 3 years community supervision, assesses a $1,500 fine, restitution in the amount of $180, orders the defendant to pay court costs of $290 and reimbursement fees of $515. Mr. Thompson, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you go over with Sergeant Martinez. He's going to take your fingerprints. Once you are released from the Van Zandt County Sheriff's Office, if it's today, within the next couple of hours, then you need to report today to the probation department. If you can't, then you need to get with her. She'll give you an appointment card, the probation director there, so that you can make an appointment and go in and get started on your probation, okay? All right, go ahead and see Sergeant Martinez. Mr. Schmidt, is that all you have today? Thank you, sir. All right, Mr. Abiyabuchi, if you want to come up. All right, court is back on the record in cause number CR 26-53, State of Texas versus King David Abiyabuchi. All right, Mr. Bingham, Mr. Hernandez. Okay, please. Thank you, sir. Guess I missed a couple of fills on that last plea. Should be coming through. All right, Mr. Abiyabuchi, the state has filed its motion to dismiss, and the court is granting that. And so this will be filed with the clerk. It'll be provided out to the Van Zandt County Sheriff's Office. It may take a little bit for the wheels to get rolling from here to there, but you'll be released today. If there's no other charges, I believe, Mr. Bingham, you said there's a immigration hold?
There's
Okay, so are there any other charges that Mr. Abiyabuchi is being held on in Van Zandt or any other charges? separate than the immigration?
No, sir.
Okay, so you've concluded all your business with Van Zandt County, so you'll just be held for whatever detainers are placed on you by Department of Homeland, ICE, whoever it may be. Okay? All right. Thank you, Mr. Bingham. Thank you, Mr. Hernandez. All right, I believe that does conclude the court's afternoon docket for the criminal cases, and we are adjourned. Mr. Bingham, you have to rush back to Smith County?
No, sir.
Can I talk to you for a little bit?
Sure.
All right.